Please be seated. So if I could begin by saying it's absolutely a pleasure for our court to be here today, holding an official session of court in this magnificent courthouse. It's been almost 20 years since we've been back here having a session of court. Judge Piggott started, I think, the Have Gavel Will Travel, and we're happy to start it all, or recommence it last year and again this year here in Syracuse. I want to start by thanking our administrative judge, James Murphy, who's with us today, and his staff for all the accommodations and helping us put this session of court on. Thank you, Judge Murphy. I'd like to also introduce the members of our court that are here in this session. To my immediate right is one of your favorite sons from Syracuse, Judge John Centra. To my immediate left is Justice Aaron Perodato from Buffalo. To my far right is Justice Edward Carney, another favorite son from Syracuse. And to my far left, the third favorite son. Not the youngest, but the third. Judge Brian DeJoseph. And we are all, I can speak for our court, we are all very pleased to be here today. One of the goals of the Have Gavel Will Travel and bringing cases to different parts of the Fourth Department is to more fully expose the work of our court to the different parts of the Fourth Department, which, as you know, is 22 counties, so it's a pretty sprawling district, and to be able to open up the doors of the courtroom to people that couldn't otherwise travel or wouldn't be inclined to travel to Rochester to hear us. The more the public sees an open, transparent disposition of legal cases, I think the more faith they will have in the outcome of the cases and the institution of the courts themselves. And so we will endeavor to return to Syracuse, I promise you, and I hope it will not be 20 years before we're back here again. Now, before we get underway with the calling of cases, I believe the clerk, we have a swearing in to do today. Is that right? Could we please begin with that? Christopher Ray Clark. Yes, sir. Member of the bar. Welcome to this wonderful bar association that you have here, this wonderful legal community that you have here in Syracuse and Onondaga County. There was a dinner last night that was held by the Bar Association that brought together judges, retired judges, active judges, new lawyers, older lawyers, and they were celebrating the careers of two wonderful members of this legal community, both a lawyer and a judge, and for the work that they've done throughout their career. I would suggest to you that at the beginning of your career that you look to people like that as mentors and as some people that you could follow in their footsteps, because there are people in this community that have led the way and paved the way for new lawyers, and it'll make your career a wonderful experience. Good luck, Godspeed, and welcome to the bar. The first case on for argument today, People versus Ramos, case 1121. Oh, excuse me, my apologies. That's a submitted case. The first case on for argument is 1127, People versus Gazillo. Yeah, right. Let's wait for Mr. Sarando to get settled.
Oh, I apologize.
No, no reason to apologize. Just
Usually John's ahead of me.
We'll get situated. All right, thank you, counsel. Please proceed.
Donald Gerace appearing on behalf of Ms. Gazzillo. This is a very interesting case, at least from my point of view. It's a very interesting case. And I'd like to talk about the second point in our brief. It's pretty clear to me that the prosecutor, who was a career prosecutor, very experienced, failed to notify the grand jury when a witness gave at best misleading testimony, in my view, false testimony to the grand jury regarding.
Well, that's really the question, isn't it, right? So
Yes.
the questioning in the grand jury, she was asked, you were also able to, she was supposed to stay out of trouble, she's supposed to remain drug-free. She's asked, were you also able to remain drug-free? She says, yes. You did not test positive for drugs? Yes. During that time, did you fill your obligation? Yes. So, and there was a positive test, when, in August, right?
Yeah, I believe there was more than one positive test, but the DA was aware of the positive test in
Okay,
August. Because
so
probation brought it to DA's attention.
Her agreement was in April of 2016. The controlled by was June 8th of 2016. She tested positive thereafter. So the people's position is that her obligations under the contract were done, right? And so it really was not misleading for her to say, I fulfilled my obligations during the term of my agreement.
I disagree with the DA's version of events.
I assumed you would.
The agreement obviously required the paid informant, both paid informants actually, to testify truthfully, both before the grand jury as well as at any trial of the matter. And the agreement clearly states that. So
your argument is even though the positive drug test took place after the sales and after the
still a violation
thing,
of the
still
agreement.
a violation of the agreement.
Still a violation of the agreement. And additionally, the DA chose to present only one witness regarding incriminating evidence against my client before the grand jury. The grand jury was denied the opportunity to know crucial facts regarding the credibility of this particular witness. Not only did the DA not correct the misleading, I say false testimony, when she had the opportunity to do it. The DA clearly knew it was false because the probation department had notified the DA that they wanted to violate this particular witness for the failed drug test regarding her supervised release, as well as the agreement that she had
Well, she knew about the drug test, but just so I'm clear, and I think Justice Perodato is hitting this point, it's the context within which the testimony was given. In other words, the June 8th event, at that time, had she been violated?
That's what the DA says.
Right, that's their argument.
Yeah,
right.
But it's clear from the language that's not. And she's a career prosecutor. I'm an ex-prosecutor. She knew what she was asking, and she also knew what the response was.
So you're saying at a minimum, there was a requirement for the DA to clarify the testimony.
To clarify that.
Because it may have been ambiguous.
Exactly. And this witness was offered the sweetheart deal of all sweetheart deals. She was going from Class C D&E felonies with potential state prison sentences to a misdemeanor and a conditional discharge. Well, that was not disclosed.
Well, the grand jury knew that there was
a deal. The grand jury did not know the extent of the deal.
Yeah, but there's no requirement under law that they have to tell the grand jury that there's a plea agreement.
The prosecutor not only seeks prosecution, but has to deal fairly with the accused and has to seek justice. In this
so in
case,
your position, anytime they're in possession of any exculpatory information at all, they have an obligation to disclose it.
I don't know that it should be an exact rule to that extent, but in the confines of this particular case, where you only have one witness who's a paid informant, that is the only witness that can testify to incriminating conduct, the grand jury was denied the opportunity to fully vet this witness's credibility. And in addition to that, the DA knew that this was obviously Brady material. We're not talking about a first-year prosecutor. We're talking about a career prosecutor, the DA in the county. So when the defendant was arraigned in county court on the sealed indictment, She did not disclose this information to the defense nor the court.
Wasn't it disclosed, though, well in advance, to give defense lawyer an opportunity to prepare for cross-examination?
The
I mean, he
defense
knew about it,
lawyer,
he
the
did
defense
cross.
attorney found out about this Brady material when, after the jury was sworn,
Correct.
while preparing a witness. The DA never disclosed this information. And the problem with that, Judge, and it's the reason why we have the Brady rule, and I don't mean to be preaching to the court because you know this stuff better than I do, but the purpose of the rule is to disclose potentially exculpatory information at the earliest time. And that's to allow the defense to be able to use it, to investigate it, to do things, to find out the substance of it. That wasn't done here. Not only that, the DA not only did not disclose it, there was a court order directing her to disclose it as early as possible, and she didn't comply with the court order. In fact, the DA never disclosed it. It was only admitted to after the defense brought their motion for re-argument on the grand jury dismissal on the basis of the grand jury being tainted by the prosecutor's conduct before the grand jury. So this is a unique case because of the circumstances. The only evidence of guilt are the paid informants. They both violated their pretrial releases. They both violated their cooperation agreement with the DA. And the information was really, the defense attorneys were playing catch-up, Judge. That's the best way to describe it. And they never would be allowed to be able to catch up because clearly there were several months between the indictment, the arraignment, and the trial. They could have fully investigated this matter more fully. And then the court compounded that by, in my opinion, committing reversible error by not making there a consequence for the prosecutor's acts, and by only allowing a continuance to the next day, which doesn't allow the defense to do any appreciable investigation of the information that they were granted.
Counsel, you should begin to wrap up.
I think I'm pretty much done, Judge. I'm pretty good with clues from the court. I thank the court. If there's any other questions, I'd be happy to answer. Other
Thank
than that,
you.
I'll rely on my brief.
Morning, Your Honor. I guess welcome to Syracuse. John Sarando on behalf of the Lewis County District Attorney's Office. The focus of the grand jury was on June 6, 2016. And I think the DA, in the argument on the motion, indicated that she was truthful, drug-free at the time of the sale.
But don't you think that,
Clearly,
don't you
she
think that would have called for some clarification by the DA when that testimony came out?
I think she should have said something, but she didn't, and we're left with the record as it is. And I think when you look at the case law, did that affect the prima facie case of what was being presented to the grand jury, or did it solely go to the credibility of that witness? And we submit, obviously, it went to the credibility of that witness, and when the court looks at it in terms of the Holmes case, the Bartolomeo case, Hansen case, it's all, did it affect the prima facie evidence? And the answer to that is no. Should it have been clarified? The answer to that is yes. But we're stuck with the record as it is, and I don't think, insofar as the disclosure of the cooperation agreement that was fully disclosed, and I think page 6 and 7 of the grand jury minutes, insofar as the Brady rubric that he's speaking of, you have, they had ample opportunity to use that information. Not only did they talk about what she did, were able to get through the probation department, I believe, what she did during the term of the contract, any pitfalls that she may have entered into, but they went back previously, and I think they looked at her prescription records for 2015 and to see the oxy that she got during those times, which obviously she was using or selling But that was fully explored, and the credibility of this witness was, and her husband were fully explored, and the jury, credited that testimony, and they had,
Mr. Sarando, if I may.
yes,
There are three issues that counsel are talking about. The grand jury issue, the extent of the cooperation agreement, and the failure to timely disclose Brady material. Maybe not in isolation they're a problem, but what about the combination of those three issues? Does that equal unfair trial?
an unfair trial? Oh, no, Your Honor. I
The
think
three of them combined, maybe not one standing alone.
the grand jury aspect, being solely related to credibility, was fully explored at trial, i.e. the witness's credibility. The cooperation agreement was fully explored at trial, i.e. credibility. The quote, Brady material was fully explored at trial, i.e. credibility. So we submit that it did not deny the defendant a fair trial. And we'll rest on our brief. Thank you.
Thank you, counsel. Case 1128 and 1129, People versus Nicorvo.
Good morning. Mark Foti on behalf of Mr. Nicorvo, the defendant and appellant in this matter. There's two categories of issues here. The first relates to suppression of statements, and the second relates to youthful offender adjudication. I'd like to talk about first, point one of the brief, which relates to the suppression of statements. The trial court recognized that the circumstances here involving a 15-year-old escorted from location to location and ultimately placed in a room under police supervision, subjected to multiple instances of police questioning without Miranda or his parents present, constituted custodial interrogation. There's at least circumstances, given the fact that he's 15 years of old, would suggest that Mr. Nicorvo had no reason at all to have any conclusion drawn other than...
Counselor, I don't think there's no dispute of the facts of what you just stated. Does custody really matter in this situation? Because the court seemed to focus solely on whether there's custody or not custody, the emergency doctrine. Because even if with custody, granting what you're saying is true, he's held, we know it was a lockdown, but we're really dealing with the emergency doctrine. So really the focal point of this argument should really be whether or not emergency doctrine existed. And I think you'd have to agree that if it did exist through all the interrogations, then you have a problem.
I agree that the focus here really is on whether the emergency doctrine existed. I had noted in the respondent's brief there was still some argument on the custody issue. But in regards to the emergency doctrine is where the court erred. The emergency doctrine was applied in this case, as the respondent argued, as the people argued, based on exigent circumstances under the emergency doctrine, as there could have been a secondary armed actor providing a threat to students and faculty.
And counsel, didn't we have a Deputy House, who I think was the first law enforcement officer, if I read the record correct in this case, to interview or talk with the defendant? And at the conclusion of that interview, didn't Deputy House conclude that he didn't think there was an ongoing threat?
That's correct. And I think, although the court's correct that Deputy House was the first member of law enforcement that had contact with Mr. Nicorvo and questioned Mr. Nicorvo, but I think what's notable is actually the second member of law enforcement, Deputy Mangino, I hope I'm pronouncing her name
The
correctly.
school resource officer.
Yes, because prior to Deputy House ever having contact with Mr. Nicorvo, Deputy Meningo had an opportunity to speak to Mr. Nicorvo. She enters the room where he was kept out, sort of off of the classroom, and her behavior at that point is not consistent with somebody who believed that a present emergency existed. She basically suggests that she spoke to the other members of staff who were there, said, do you guys need anything? No. She ends up leaving the room. Now, later on, there's this narrative created that there is this sense that there was an emergency in existence, and certainly that's what the case law, Michigan versus Fisher, would support, that there has to be reasonable grounds to believe an emergency was.
But isn't it a fair assessment to say, look, I mean, what was known at that point was that you had a young man who had a weapon, who had ammunition. The weapon was loaded, I believe. There was additional ammunition, and he was pulling it out of a case when he was confronted by one of the school personnel. And so, shooter on campus, you'd agree, is an emergency situation.
I would agree that specifically this type of situation, which is part of a sort of horrific trend of school shootings, has given rise to a great deal of societal fear. But I don't think that that fear can overcome the inherent fairness that the criminal justice system is supposed to provide. I don't believe there was any evidence to suggest that there was any second shooter.
But the emergency situation, it requires, doesn't it, the law enforcement to cross the T's and dot the I's in terms of investigation to make sure that this was not a group of young men who had met, who were going to the school that day, and we're going to do this as a team event, right? And so isn't that something that they have to and should properly nail down? They shouldn't assume, should they, that the emergency's over once they find one shooter?
Well, I think in almost, Your Honor, in the response to almost any crime, it could be argued that that crime itself has presented a circumstance that could be described as an emergency.
So why don't you tell us this? We know it's a three-pronged test, and the first prong is the police must have reasonable grounds to believe.
Right.
So tell us under the facts and circumstances of this case why that belief was not reasonable.
So I think I can point to two specific points that I think are dispositive that the law enforcement legitimately did not have reasonable grounds, and I think grounds to believe that there was an ongoing emergency, and I think they knew that themselves. I did refer to Deputy Mengingo having an opportunity to question him and not taking that step. I also would suggest that the information that appears to be circulated at that time was all consistent with there was a single individual involved, the gun is secured, the emergency's over.
But that's coming after really all of the questioning. It seems to me it was not unreasonable for these officers to make sure that there wasn't a second shooter. That seemed to be, I mean, their testimony consistently was, we wanted to make sure he was acting alone, and then, of course, part of the testimony was we wanted to make sure that he was no longer a threat to himself because there was a suicide note that they found.
Well, I guess I would refer in terms to the record to the point where the police who responded indicated they responded to a dispatch call, and that dispatch call had conveyed information that it was an individual who has been detained and the gun has been secured. The information that appears as being conveyed to police almost initially.
I take it your position that the emergency ended after Sheriff or Deputy House concluded his interrogation.
I think
it's over?
I think that the emergency ended the moment, I mean, quite literally, the emergency did end when Mr. Nicorvo was detained, and I don't think that there was any evidence to suggest that there was an ongoing emergency at that point. But can I also point out that for the evidence to be admissible, for the questioning to be admissible, it has to be consistent with questioning that related to the emergency doctrine. Okay? And I think the biggest clue is when the detectives go in, they're the third set of officers who have contact with Mr. Nicorvo. They say to him, they ask the question, was anybody else involved? He says no, they step out of the room. And if you look at the cross-examination of Detective Kittleson, he specifically answers the question that they left after that point because they were trying to protect the defendant's legal rights. They recognized that there wasn't any further appropriate questioning. Now, Deputy House spent 5 minutes questioning Mr. Nicorvo. It wasn't about, is there another person? He was asking, what did you do this day? Where did you keep the gun earlier today? He asked about his
Yeah,
intent.
Counselor, aren't those questions really in essence to determine, you're going and you ask a suspect, any other people? No, and then they're supposed to walk away. I think they're reasonable for them to make further inquiry to see whether or not the statement he's making to them has some consistency or some value or truth to it. And in this situation, see, I read your brief a little bit differently. I jumped on what my colleague Justice Joseph said. I thought at the beginning you were arguing that there came a point in time earlier on that they knew the threat was no longer there. So there may have been an emergency doctrine potentially available to the people to utilize here, but because of because after he tells the principal and the other teacher and then the multiple detectives that were there, that was overkill, and it should have ended earlier on. That's the way I read your brief.
No, I did make that that was my intent to advance that argument. I think we maintained the position that the emergency doctrine was no longer available once the questioning proceeded beyond is there anybody else involved, or questions specifically related to that. But in any event, we also acknowledge there's 3 separate instances of questions. There's breaks in between, time that passes, and then ultimately officers return to them and now start asking questions again. And I don't know that you can continue to try to rely on the emergency doctrine when it's already been established by law enforcement directly that this emergency, this ongoing...
Whether or not it's legitimate that they continue. I think we have the argument on that issue.
In regard to the second and third point of the brief, both relating to youthful offender adjudication, I understand that case law has developed out of the Court of Appeals that suggests that the trial courts in certain circumstances may not have to go to certain lengths to explain the determination that they're making and their reasoning for it. However, in this case, I think it's uniquely suited for determination that the court did not complete its obligations under Section 720 of the Criminal Procedure Law. And although...
Are you asking us to expand the rule?
I'm not. I'm asking the court to review the facts of this case.
It
and make
wasn't done, you're suggesting?
Correct. I believe that's established by the language of the court itself in the pivotal moment in the proceedings when the court makes a sentence promise to the defendant. The language used was very specific. The court said at that time, I will not consent to consideration of youthful offender adjudication. That is incredibly powerful language. He's indicating to the defendant, in consideration of any plea offer, he will not even consent to consideration. And I know that there was a number of comments made afterwards about I haven't made any commitments, that we could argue over the ambiguity of those, but when considered the full context of the record...
You're saying he's got an obligation to at least consider YO. Maybe he's not going to grant it, but the judge has to at least consider it.
Absolutely. And he says when he is making the sentence promise, he says, this is a serious crime. I'm not going to consider youthful offender adjudication. At sentencing, the prosecutor says, no further argument than this is a serious crime, the public should know about it, and he says, I'm denying youthful offender adjudication for that reason. This court could find that the circumstances involving...
Let me ask you this, counsel. It's an interesting point that you raised, but you know, if a judge were to say earlier in the proceedings that I'm not going to consider a youthful offender, your argument's very strong. If later in the proceeding the judge indicates that he or she has considered youthful offender and then denies it, wouldn't that be the judge considering youthful offender and denying it?
I do think that the court could retract its prior comment and indicate that I know I said I would never really consent to giving due consideration to this issue, but I have. And in this case, that could have been demonstrated by going through all the mitigation that existed. Mr. Nicorvo was a 15-year-old with mental health issues who had to receive treatment during the pendency of this case. I mean, without considering the facts of the case or the seriousness of the offense, this is one of the most obvious cases called out.
Is part of your argument that you think that information was not available to the judge in this case for purposes of sentencing? Because I think it was.
Oh, I think it was, absolutely.
Yeah.
And I think that the court...
So you're saying the court may have had it available to him but didn't consider it?
It doesn't reference that at all and merely refers to that this is a serious offense, which is consistent with what was said at the time of the sentence promise when the court indicated, because it's a serious offense, I'm not going to
So
consent.
is your position the court has to articulate its reasons? I think the case law is clear from the Court of Appeals.
I don't think that the court, under these circumstances, would have had to articulate their reasons had they not already indicated that they are not going to give due consideration to the issues.
I think we have that argument, counsel.
If the court has any other questions, otherwise, I rest further on the papers.
Thank you.
Thank you.
Good morning. Nicole Kyle, Jefferson County DA's Office for the Respondent.
Counsel,
Yes.
maybe we just pick up on this final point. I know there's other issues you want to address, but that is pretty strong language by the court. I've not consented to consideration of YO status.
Oh, we would ask the court.
He's basically saying I won't consider it.
I do not feel that at all, Your Honor. If you take the whole conversation in context, he goes on then to state that he has not yet made a decision, is not guaranteeing a YO determination at the time of sentencing. It's clear from the record that at the plea, he talks about, I have not yet decided, and then at sentencing, he hears from defense counsel, who puts on a vigorous argument to grant YO. He hears from the people, and he hears from the defendant himself. So the court is obviously weighing if he is going to grant a YO determination or not.
Counsel, the emergency doctrine applies, let's argue.
Yes.
But at some point, doesn't that end when the officers make a determination that there's no longer a threat? And once that emergency situation ends, aren't we in a different posture with respect to the rights of the defendant?
That's correct. I would agree with that, Your Honor. However, I would submit in this case it did not end. I do understand we have three separate officers, well, three separate times law enforcement speaks to the defendant. In regards to the first two, we have Deputy House that comes in and he speaks to him very briefly. And he does go over what's going on. Are you alone? Is there some other threat? We have a school with, I believe, over 1,000 people in it, according to the record. And we have a fluid situation that's evolving and officers not talking to each other as they arrive on scene. Deputy Mangione was a school resource officer, familiar with the school, familiar with the students, also comes to speak, and she says to what's going on, there's a suicide note, is the defendant okay in case he ingested any type of pills? I think she says in her in her hearing testimony. And then she's like, are you okay? And do you have anybody else? Is there somebody else we have to know? And she leaves. Detective Kittleson and Pasisi do come in a little bit later. However, they just arrive at the school. And they believe their testimony was they have not spoken with the other officers. Should they have? I cannot answer. However, this is a fluid situation that's on lockdown. They said the canines are coming to search through the school for possible, incendiary devices, and they just don't know. So I would agree that at time it stops, but I don't think it happens in this case. Anything else?
No further questions. Thank you, counsel.
Thank you.
Case 1130, People versus Uruta.
Good morning, Your Honors. Peter Banishak for Jamie Arudia. Our main contention on this appeal is that the prosecutor's repeated and purposeful violation of the trial court's ruling relating to Justin Fernandez requires reversal. The court clearly ruled that the prosecutor was not permitted to question Fernandez about Mr. Arudia because Fernandez was a witness called by the co-defendant in this joint trial. The court further warned...
He was obviously not called by the people during their case.
Exactly.
So, yeah.
In addition, the court warned the prosecutor that if you do go down that road, it would be grounds for a mistrial. Despite that, the prosecutor proceeded to ask more than half a dozen questions in violation of that ruling over repeated objections, and even after being admonished by the trial court and told to ask leading questions.
Counsel, was there a curative instruction here, though, with respect to that conduct? That
Judge,
questioning, I should say?
There was a curative instruction, at least with respect to some of the questions. I think there's at least 3 reasons why that's not sufficient.
Was there an objection to the curative instruction?
No, Your Honor, but there was a request for a mistrial, so I think defense counsel clearly put the court on notice that a curative instruction wouldn't be sufficient here, that there had to be a new trial.
And that's really the question before us, because I agree with you that the questioning by the prosecutor was troubling. The issue, I think, for us is whether the fact that the court immediately sustained all the objections and issued these curative instructions, whether that was adequate or not, right?
It is, and I think there's 3 and perhaps 4 reasons why it's not sufficient. I'd point the court to the Court of Appeals decision in People v. Carbonaro. There, the Court of Appeals said that limiting instructions are not sufficient in every case, and that's because if they were always able to eliminate the prejudice caused, prosecutors would essentially be able to act with impunity, secure in the thought that if there's a guilty verdict, and it will be upheld just because there were curative instructions. On top of that, this isn't a case where there was 1 question or even 2 questions. I think in all, our brief mentioned 7, but I think it gets up to about 9. So we're talking about pervasive questions.
Did I also read in the record that after the 6th or 7th or 8th incident, there was a prosecutor who lost his or her temper, was admonished for slamming things on counsel table? Did that take place in front of the jury?
I believe that was once the jury was dismissed.
Okay.
I don't believe I can say that was in front of the jury. But I think what that does show is that the prosecutor asked these questions because he disagreed with the court's ruling, not because he didn't understand it. So I think it shows deliberate and flagrant conduct, and that's another one of the reasons why the instructions would be insufficient. Another reason why they're insufficient is because defense counsel had to repeatedly object to questions which implicated Mr. Urrutia in this crime, and I think he had to do that in front of the jury, and it made it look as though he was hiding something from the jury. And but for the prosecutor's conduct, that wouldn't have happened. And finally, the 4th thing is that even after the court denied the mistrial, the prosecutor, I think, engaged in some gamesmanship in that he told the witness, "I need you to stay very vague pursuant to the court's ruling." And then essentially referring to the prior testimony that Fernandez had provided, he said, "And did you randomly run into this quote-unquote mysterious person? When you got picked up by this quote-unquote random person, did you know where you were going?" So I think even those questions were relating back to the improperly asked questions and the improperly given answers. And as a whole, Fernandez's testimony was powerful proof from the mouth of a confessed participant in the crime that Mr. Urrutia was directly responsible for this assault. And in our brief, we primarily rely on this court's decision in People v. Hancock, where there was likewise a pretrial ruling, a violation of that ruling, an admonishment by the trial court, and then a second question. Here, we have even more than that, and I think it's a more egregious error and a more egregious violation of Mr. Urrutia's right to a fair trial, and therefore we ask this court to grant him a new trial. Thank you.
Thank you, counsel.
Morning, Your Honors. Brad Osler on behalf of the people. I submit that this case is distinct from Carburano or from Ryback, which is a similar sort of case, for a couple of reasons. Number one is that unlike those cases and some of the others in the same vein, we don't have I'm going to use this word, the pervasive conduct that could introduce prejudice or upset.
All right, no, wait a second. So the prosecutor here repeatedly asked questions of this co-defendant in violation of an advance court directive not to do so, and the questions that were being asked were seeking to implicate this defendant in the crime. So how is that not pervasive? It seems to me it happened, you agree it happened multiple times.
Yes.
And the court had to give curative instructions and sustained all of the objections. So how is it not pervasive?
What I'd submit is that I think the pervasive conduct that we often, or that we see in some of these other cases, is conduct that occurs from the opening through the actual cases in chief and then into the summation sometimes even. Here we have a span of, I don't know exactly how long, but a relatively short period of time.
Pretty crucial point issue here, though. We're not talking about some kind of secondary issue here. This goes really right to the heart of the case, doesn't it?
It is a piece of evidence that obviously the people wanted to be introduced to the jury. Testimony from somebody that was on the scene that this defendant was also on scene. the rest of the evidence that the people did have, which would include several other eyewitnesses, all of those witnesses were largely consistent on a lot of the relevant facts. I think the fact that the people were trying to get into evidence testimony here from this co-defendant, the fact that the objections were made protected the integrity of the trial.
And I
here.
think that's the point counsel's making, is that but for the fact of the objections and but for the fact of the court being astute enough for the curative instructions, why should it save the people's case? Because without the curative instruction, your burden would be much more difficult at this point.
Correct.
So now it's the court that saves the conviction as opposed to the ADA, that obviously the conduct was not appropriate.
Well, and the spin that I would put on that, Judge, I guess spin's maybe not the right word, but is that the evidence aside from this was sufficient on its own and credible.
I would think your better argument is not to get into the number of times it took place. The standard for us is whether the court abused the discretion in not granting the mistrial, and there's a presumption that when a court gives a curative charge, the jury is following it. I think you should, I would think your argument is you should focus on that, what effect it had on the jury, not the number of times the prosecutor did what he did.
I agree, and I think that's, you know, the pertinent rule from Carbarano that a curative instruction cannot always cure prejudice that may have resulted during a trial. I think this case is distinct from that, or would that the curative instruction here would in fact save whatever kind of error was occurring. It again was a relatively limited exchange. The jury, for the most part, did not hear evidence that was not supposed to be introduced, and then the court kind of, I think, astutely paused the proceedings, sort of reset everybody, corrected the jury, or provided corrective instruction to the jury, and allowed the case to then proceed.
Opposing counsel talked about some follow-up questions using, some unknown name, unknown individual. What's your response to that?
Sure. Well, I submit that if you look at those questions kind of in a vacuum, just to, if you're a juror that has little idea of what's going on, that question's not prejudicial.
Can you look at it in a vacuum, or do you have to look at what's just happened here?
Well, I think the prosecutor was doing his best to comply with what the court had ordered at that point, and he was just trying to flesh out some of the background facts about how this, or what led up to the event. While the language it would give you some pause if you're a juror and you're hearing somebody say, well, when you found this random person, what happened?
In view of what had just transpired.
Well, sure, but it's not implicating the defendant in this case, and assuming, as we must, that the jury in fact followed the court's instructions. That's simply just sort of an oddly phrased question. It's really not. It's something that's introducing prejudice or somehow trying to, yet again, sidestep the jury's or the court's instruction at that point. I think the rest of our points are made in our brief, unless there's any other questions.
Thank you, counsel.
Thank you.
Case 1131, People versus Williams.
Good morning, Your Honors, and may it please the court. Kristen McDermott on behalf of Joshua Williams. In this case, Harry Shelton murdered Nicholas Hill. The people did not present any evidence that Joshua Williams asked him to commit murder, that the two men had an agreement to commit.
So as I understand your arguments as to weight and to insufficiency, really it's all about that there's no specific agreement in evidence of this agreement between these two individuals to kill the victim.
Correct, Your Honor.
And that there's a lack of shared intent. And so what I want to hear from you is, why don't you marshal the facts that show us that it's either against the weight or it was legally insufficient, as you see it. As I understand it, the key to your argument in your brief was that Mr. Ernestine's testimony was a central part of this case, and it's incredible, and that the other testimony brought that credibility into question, and therefore it's either against the weight or insufficient.
That is our weight argument, that Ryan Ernestine's testimony is particularly and highly incredible in this case. I would point out, though, for our sufficiency argument, even if this court takes Ryan's testimony entirely to be true, it still should reverse. The only evidence that the people have that Joshua Williams shared Harry's intent was that in the car he asked for a gun and he said, "I want to put a bullet in him." But importantly, Harry said no. Harry turned him down. He said, "You don't need a gun, let's just beat him up." And he said that twice. So if there's any agreement that can be gleaned from that conversation in the car, it's that no one is gonna shoot him.
But that ignores the facts that then they dropped by Harry's house, right? He went in, it appeared at least there's some circumstantial evidence that he retrieved a gun. And then later, there was an altercation. And then, at least from your perspective, Harry did the shooting.
Correct. There's no evidence that Joshua knew that Harry was going to get a gun. Harry said that he wasn't going to. Joshua told police that he thought Harry was going in there to get drugs because Ryan was a heroin addict and would drive people around for more heroin.
What about the evidence of defendant's statement right before the shooting? He says, "We got to do this now," especially when he says "we." Isn't that also isn't that kind of added to the mix of the circumstantial evidence of his intent?
Respectfully, Your Honor, respondent's brief mischaracterizes the orders of events on this fact. Nick Hill Jr. heard Joshua say, "We got to do this now," before the physical fight. And we are not denying that Joshua intended to beat up Nicholas Hill. He intended an altercation with this man.
So you're saying that shows an intent to assault him, but not kill, but not participating in the shooting?
Correct. And Nicholas Hill said, "My kids are here." And Joshua said, "We got to do this now. I'm going to fight with you now." But when Harry pulled out his gun in the middle of this encounter and drastically escalated the level of force to murder, there is no evidence that Joshua Williams intended that to happen. There's no evidence that Joshua knew that Harry had a gun. As I said, he thought he went to his house to get drugs. And Ryan Ernestine specifically testified that no one in the car knew that Harry now had a gun.
But you have to admit that the statements being made in the car, if you take Ryan's testimony, and the statement that was, he went down and got him from his bedroom, brought him out, we got to do this now. I understand the fight can give rise for the consideration for some joint intent, shared intent. I think that's the nub of the whole issue is that, 'cause that's really what ties him in, isn't it?
Correct. The case law says that the proof must exclude any purpose other than intent to kill. So if there's any innocent explanation for Joshua's actions that can arise from this evidence, then he can't be held responsible for Harry's
So tell us how you get around the statement that it was testified that your client made a statement in the car that he wanted to put a bullet in the victim.
At most, that shows Joshua's own intent to shoot Nicholas, not that he wanted Harry to do it for him. But I would argue it really doesn't establish the intent element. I think he was angry, he was drinking, he was on cocaine, he was talking tough, and he said, "I want to put a bullet in him." That's the kind of thing that people say, and there's really no indication that he would have actually followed through and murdered someone had he been given a gun. But even assuming that this does meet the intent element, that only gets us halfway there. You need a mens rea and an actus reus, and there's no act here. He didn't ask Harry to kill Nicholas for him, and he didn't intentionally aid him in doing so. We can look back on this and say in hindsight that his actions may have aided the murder, but there's no evidence that he did so intentionally, because we don't know that he knew what was about to happen in that room. He thought they were just going to have a fight. If I could also address the weight argument, even assuming that this court finds this sufficient, we do believe that Ryan was such a highly incredible witness that this is one of the rare cases that this court should overturn the lower court's credibility determination.
Okay, so let me help you out. You say in your brief that there's a number of things that weigh in your favor. You say that the testimony, really the central part of the case, was Mr. Ernestine.
Correct.
You say that he was a heroin addict, that he had a deal with the district attorney's office, that there's a little bit of inconsistent testimony relative to where he was, whether he was upstairs or downstairs
Correct.
when the altercation took place, and that that this individual, Ashley Voigt, is it?
Correct.
She contradicts the motive for the altercation, and she never heard in the car anything about the shooting or asking, I guess, Mr. Shelton to get a gun.
Correct, she didn't hear any of those statements. I really cannot stress highly enough that Ryan was getting a fantastic deal for himself. He was facing 15 years in prison. This is the second time that he tried to put someone else in prison in his place. He ended up with time served, and he asked for local jail time in exchange for...
Isn't this all about credibility, though?
It is. And we are asking this court to sit as a 13th juror, and we're saying that the trial judge got this credibility determination wrong. Ryan was testifying to get a really good deal for himself.
Yeah. It's not lost on us that Mr. Ernestine got a great deal, and the other individual was acquitted, right? Is that correct?
Harry Shelton was acquitted after he went to trial and blamed the entire shooting on Joshua Williams. Just to address one last thing, I think it's very significant that Ryan Ernestine was caught in a lie on the stand. He said that he initially told the grand jury that he didn't see, that he immediately went down to the basement after he got home and he didn't see anybody go get Nicholas from his bedroom. At trial, suddenly for the first time, he made up a story about sitting in the kitchen and seeing Joshua
But it's not, as Justice Carney pointed out, I mean, that's in front of the jury. It's part of the credibility or lack thereof. Everybody was either using cocaine, drugs, heroin, alcohol, and all that, once again, was before. So the jury makes the determination on that one misstep or that one, maybe you would say, lie, and they weigh that as part and parcel of the credibility. So really what it boils down is a credibility issue, which you're emphasizing that the jury got wrong.
That's correct. The fact finder in this case was the trial judge, but I would also point out that the trial judge didn't understand the significant benefit that Ryan got in exchange for his testimony, because in response to the 330 motion, the trial judge specifically stated that Ryan would be going to prison for these unrelated charges. Even the trial judge didn't know that he had saved himself a decade in state prison to give this testimony.
Is it clear on the record what the bargain was?
The prosecutor admitted that Ryan Ernestine was looking for local jail time. His attorney had asked for local jail time. We know that he ended up getting time served. The prosecutor claimed that there was no definitive deal, but we know that what was in Ryan's mind when he gave this testimony was, I'm going to try to get out of going to prison altogether.
And, well, he did say that he was hoping for some consideration. He wasn't hiding that.
Correct.
The court knew that. Just the extent of the consideration is, I don't know if that was established anywhere, is it?
Just that Ryan himself believed that he was hoping for local jail time is all that the record does say, Your Honor. Thank you.
Counsel.
Good morning, Your Honors. Ken Tyler for the people. If I could just start with Justice Carney's question to my counterpart, the legally sufficient evidence of the intent here. I would marshal the following facts for you from the record, and of course they're laid out in detail in our brief. Defendant expressly and repeatedly requested his co-defendant to go get him a gun so that he could shoot the victim. He aided that effort when they got back to the house by procuring the victim's presence in the dining room. That's corroborated by multiple witnesses. As the panel pointed out, witnesses heard the victim pleading for his life, stating, my kids are here, my kids are here. I would submit to you it's inferable from that what was about to happen in that dining room was something more than getting beat up a little bit. Right after that, a gunshot rang out. Defendant fled the scene with his co-defendant. He later remarked to Ryan Ernestine that he knew the police were looking for him for what he had done. Considering all those things together, I would submit to you the evidence was legally sufficient to establish his intent to kill.
Now, on the weight, as I understand defense's arguments in their briefing here today, they're talking about the credibility, really, of the key witness, this Mr. Ernestine.
Yes, Your Honor. I take their argument to be he's incredible as a matter of law. He could not be believed, and I'd submit to you the issues raised, while some of them are legitimate, they are classic credibility issues that are left to a fact finder. Any inconsistencies in Ernestine's testimony versus anybody else's testimony. Those were things to be weighed by the fact finder that had the witnesses in front of him, hearing them all live. And I would point out that Ernestine was credible, or at least clearly did not embellish in many other respects of his testimony. He didn't claim to have been present when the shooting occurred. He didn't claim to have seen the shooting. He didn't claim to have even seen a gun in the vehicle after they returned to co-defendant's house to what he believed to be the purpose was to retrieve a gun. He was familiar with both co-defendants prior to this because frankly they were enabling him, and there was evidence, testimony that he was helping them with a drug distribution. He was admittedly a heroin user. There was no testimony that he was high or intoxicated at the time this happened. My point being that these are all credibility issues that didn't remove his testimony from the realm of something to be weighed by the fact finder into incredible as a matter of law, physically impossible, anything like that. So for those reasons, I would ask you to affirm the credibility determinations made by the fact finder.
Thank you, counsel.
Thank you.
Case 1132, People versus Clark.
Good morning, Your Honors, and may it please the court. We're asking here, of course, in addition for the court to reduce Mr. Clark's sentence, we are asking for a remand for a restitution hearing. I think the record is pretty clear in this case that the restitution order is substantially too high, at least as to two of the victims.
Is this issue preserved? Didn't counsel, the defendant, agree to the amount of restitution here?
Defense counsel agreed on defendant's behalf, and we acknowledge that both in our opening brief and the reply brief that defense counsel did not preserve this issue on Mr. Clark's behalf.
You want us to reach it in the interest of justice?
Sure. The court should reach it into the interest of justice or find that defense counsel was ineffective in this regard. I mean, a competent attorney should have reviewed the restitution figures and compared it to the victim's statements.
Something happened here. There was one sentence scheduled, I think, for February. I believe it was adjourned for about a month.
Yes.
To kind of flesh out this restitution issue that the court was confused about.
Yes.
Preparing from the record. You come back a month later, the defense counsel does some addition, everybody's happy with it, the defendant consents to it, and here we are. So something happened perhaps in that month that we don't know about. Perhaps something happened in that month that brought defense counsel to consent to that number, and he was satisfied with that number.
Well, the sentencing record is pretty clear that defense counsel took each of the restitution orders that the prosecutor prepared, added them up on her phone or a calculator, and told the court what the total amount was. That doesn't mean that defense counsel had scrutinized the figures, and it's clear that she couldn't have, at least as it refers to Ms. Strash. The exact number that is on the restitution order, which is $2,341, is the amount that she wrote on her restitution questionnaire of stolen property not recovered.
Well, I guess my point is this, did something happen in that month that we just don't know about?
Well, I think that's kind of the problem, is the court in this case had the responsibility to fix restitution, and the court in this case delegated that responsibility to the prosecutor and to probation.
But I think Justice DeJoseph's point is if that stuff is outside the record, we don't know, and maybe you have a different remedy.
Well, based on the record that is before this court, that should give rise to enough concern that the restitution figure here is too high, and it should be remanded for a restitution
Here's the way I look at it. He's facing multiple felonies. He's facing multiple years in prison. I think he's considering himself, do I pay $2,000 less in restitution and may never pay, or am I more concerned about getting 12 years as opposed to 40 years? And at that point, a conversation between counsel and client says, you know, if it's going to affect my sentence in any fashion or form, I really don't care. And these are the issues that we're talking about that are outside the record. He consented to it. When an attorney consents to it, the defendant was present. There's nothing in the record that the defendant said, wait a second. And as a result of this, you're asking us to exercise our interest in justice and to lower it when we're really not aware of all the factors.
Well, respectfully, Judge, the defendant's plea agreement was that he would pay restitution, but there was no amount stated at the time of his plea. And then we come to sentencing, and it's very clear that there's a lot of confusion about the amount of restitution. Defense counsel makes a blanket statement that the defendant is amenable to paying restitution in general, and then at the final sentencing, defense counsel just adds up the restitution orders that were prepared by prosecution. But if we look at the PSI and the victim impact statements, it's abundantly clear that at least as to the figure that was awarded to Ms. Strash, it was too high. There was an unjust enrichment and conferred upon her.
And you say, let's get the record more clear, let's send it back
Correct.
for a hearing, and let's take testimony on this.
Correct.
I understand. Thank you, Counsel.
May it please the court, Darian Balin for the people. First and foremost, this issue is not preserved for review. Defendant and counsel were abundantly clear, and the court informed them that.
I think we're kind of past that. The counsel's asking for us to address it in our interest of justice powers. So why should we not do that? It seems like there's a lot of confusion on this issue.
There was confusion originally at that first sentencing hearing in February. The court adjourned the sentencing for there to be more communication with the victims and to get the figures straightened out. They came back for the second sentencing in March, and
See, let me give you a little shortcut here. This is the way I see it. It's not just that they didn't challenge it, he waived it. And so if the only argument in my mind that's really left with any merit is a potential ineffective assistance of counsel for things that took place outside this record that we don't have before us. And the way I see this is the only avenue for opposing counsel is by way of a 440.
of course, Your Honor, we would submit that you can determine that counsel wasn't ineffective from this record. She negotiated an extremely favorable plea deal, as Justice Sentra pointed out, and this one error, if it even was an error, wouldn't rise to that level. But if you were to find that there may be some ineffectiveness, that wouldn't be here on the record and would not be for this court's review anyways. Thank you.
Thank you, counsel. Case 1133, People versus Tripp.
Welcome.
Thank you.
Good morning. May it please the court. Linda Campbell for Damian Tripp.
We don't have the technology here.
Pardon?
We don't have the technology.
I know, I miss
Yeah,
it. My
watch this
eyes
too.
miss it. First of all, the defendant did submit a pro se supplemental brief, so if the court has any questions on that, I'm happy to respond as best I can. But I'd like to start with the conviction itself. I think, and we're talking about the assault second conviction more than anything else. I think I tried to point out to the court in my first point that the testimony of these various witnesses, whether we want to say each individual witness is incredible or together they're incredible, everybody's drunk, everybody's high, nobody really sees the same thing. But the one point that the people concede in their brief is that the shots that were fired were toward the ground. So even assuming, arguendo, that you believe these witnesses that the defendant is actually the shooter, which I would question given the trajectory of the bullet and the circumstances surrounding where this gun came from.
Does it matter that the shots, your argument is that they were fired to the ground, but they were fired also in the direction of the defendant, or the victim, and they were also fired at pretty close range.
Thank you, Your Honor. Absolutely.
Yeah.
If your intent is to cause physical injury, wouldn't you be shooting at the person, not at the ground, particularly if you're in close range? You're shooting at the ground. When one shoots at the ground, I don't know, I'm not a marksman, but being in this business for 40 years, it seems to me that if you want to harm somebody, you're not gonna shoot the ground, you're gonna shoot
Maybe
them.
he wanted to harm him but not kill him.
Well,
And if he raised his weapon a little bit, he could hit a white lord.
I
Well,
suppose,
shoot him in the leg or on the foot.
I suppose, but even if you believe the defendant's the shooter, is this a situation where the intent was to cause physical injury, surprisingly not charged as a serious physical injury, but physical injury in this case? If you're shooting at the ground, you're in close range, you're gonna raise that gun ever so slightly, and you're gonna shoot that person, whether it's at the leg or at the arm, not at the torso, that's quite of a raise, but this is a reckless crime at best, in my opinion, even if you find that the defendant was proved to be the shooter. And if it's a reckless crime, then we're asking this court to modify to an assault third. If the court, and irrespective of whether the court disturbs the assault second conviction, which of course we're hopeful that it does, either by reversing entirely in that it finds that the proof was deficient to demonstrate that the defendant was the shooter, in which case the sentencing argument becomes moot. But if the court reduces to an assault third, or even if it leaves the assault second undisturbed, the sentencing here requires modification. We've got 2 counts of weapons possession, which clearly the court believed that it was one possession, the simple possession with the possession intent to use unlawfully. And then, for whatever reason, it sentences the assault second consecutive. Those merge, so that the sentences should have been ordered to run concurrently if the assault remains undisturbed.
Thank you, counsel.
Thank you.
Good morning again, Your Honor. May it please the court. I submit that, contrary to what defendants contending, this is not a reckless issue. The intent was very clear, and I think the evidence bears that out.
Counsel, could we put intent aside just for a moment? And you've got the burden of proof in this case. You're the prosecutor. Didn't one of your witnesses say something to the effect that there's no doubt in my mind that the defendant was not the shooter?
There was a certain amount
your
of
witnesses.
There was a certain amount of inconsistency among the number that were called. I think the trial testimony, though, collectively was quite clear that the.
You vouched for the credibility of your witnesses, and your witness said that.
Well, I can't change what they said, but I think the vast weight of the evidence was very consistent, and I think that the witnesses were collectively very much consistent on the identity, the facts over the course of the evening, what happened, and then with regard to the actual shooting itself.
Didn't one of the defendant's own witnesses ID the defendant as the shooter?
That is correct. That is correct, and I think that speaks a lot to what happened here. And then with regard to the actual injury, I think the range, the use of a gun, I think it's an astute point that it's wise maybe not to shoot at the chest or torso of an individual if you're attempting to just kind of intimidate or scare them, but you certainly, or you're shooting with an intent at close range, and the injury that followed is should not be surprising. I think I would also take slight issue. There was certain admissions in terms of witnesses ingesting drugs or alcohol that night, but it was not everybody. And I think, again, their testimony is consistent enough that we are not really in a position to question the jury's determination of credibility at this point. Briefly, with regard to the consecutive sentencing, as we laid out in our brief, though there was, again, some inconsistency in terms of which individual left the scene momentarily, be it the defendant or the victim. Regardless of who it was, there was a period of time where they were both back together on the scene. The defendant was clearly possessing a gun at that point in time. The argument resumes, the shooting happens. There's enough of a time period, there's enough of a sort of a distinct act.
But even if we accept that, what about that establishes that that he had an unlawful intent that was separate and distinct from the intent to shoot the victim? Well, even if we accept what you just said.
So he had the gun for a period of time on, you know, on its own, without any, without the argument resuming or there being a sort of ongoing conflict between the defendant and the victim at that point. So we have a sort of simple possession at that point. Then the use of it, it comes afterwards, and you have the assault and the intent to use unlawfully at that point. I think the fact that the assault was the charge that was sentenced consecutively, as opposed to, I suppose, what logically should have been one possession count and then the second possession count along with the assault being concurrent to that second count, which would have lengthened the sentence here considerably. It's perhaps an oversight or a mistake, but it does not change the fact that the assault is properly consecutive to the possession, or at least to one of the counts of possession.
I think we have that argument, Counsel.
Thank you, Judge.
Case 1134, People versus McDermott.
Good morning, Purity, Georgia, for the appellant. Nice shorter drive today to come up to visit you. One basic issue in this case deals with the severity of the sentence, although we have to address the oral and written waiver of appeal, which I do in the first.
Counsel, let's just get that off the table. We know what the argument is. By miracle, nothing was mentioned regarding severity. So for the purpose of this oral argument, let's just assume you're correct on that, and nor was it contained in the written or the oral, and the defense argument is that it's an overbroad language in the waiver, and therefore somehow or another it encompasses severity. But
okay. Getting past the waiver argument, if we go to the heart of it, whether the sentence was severe, this is kind of an interesting case in that there was a lot of colloquy with the trial court that I'm going to max you out if you don't take the 20 years to life. I think the 57 years was volleyed back and forth a number of times. What ended up happening is there, at the last pretrial conference, I think a month before the jury trial was scheduled, the defendant wanted to think about the deal or make some sort of adjournment, and the judge says, you know, I'm going to give you a week to come back, kind of inferring, as many trial courts do to control their calendars, that the offer of 20 years to life is no longer going to be available.
It was 20 years to life on murder, wasn't it?
Correct, on the first count of the indictment.
Did he end up pleading to manslaughter?
He ended up pleading to the second and sixth counts and got consecutive sentences on, I think, counts 2 and 3, and then concurrent sentences on the other. I think what's significant, Your Honors, in this case is that the defendant from day one wanted to take accountability for what he had done. He took accountability during the pre-sentence report when he was interviewed by the probation officer. He took accountability when he
What do you mean by taking accountability? The fact that he wanted to enter a plea?
He wanted to enter a plea. He was concerned, and I think rightfully so, that he was going to be given a life sentence or 57 years by the trial court, and I think that weighed on his mind. So when we came back for the ultimate plea, and this is where the record's unclear.
But wait a minute, wasn't the original offer 20?
20 to life was the original offer on the top count of murder.
Right.
There's an adjournment. The judge says come back with take it by January 13th, I think it was the day, or inferring that it's not going to be there. The next thing we see is that he's pleading and getting 37 and a half years on a determinative sentence. One could read the record that he was more concerned about the life end and wanted to take the 37 years to make sure he was getting out at a definitive point. But I think in the context of the judge saying, I'm maxing you out, you're getting 57 years, that put him in the mindset of being worried about that life end sentence. Where, and the record's not clear, it would have been much better if the court or the trial defense attorney said, the offer of 20 years to life is still on the table, but the defendant has chosen he doesn't want the risk of having to go to the parole board, that he's taking 37 and a half years.
Well, the argument on it is really the fact of due to his age, due to his lack of involvement, due to the fact that he was willing to admit up front of what he did, the 37 years is awful harsh.
It is.
And if he had gotten 25 to life, obviously it'd be probably closer to life than it would be 25, and I think he recognized that. And as you're mentioning, a determinate sentence. So you really want us to do is to address the sentencing aspect of it and lower the sentence of 37 years.
Absolutely. He does not want to withdraw his plea. He does not want, he wants to
just want a lower
get less than 37 years. And I will add, he is 21 years. There's no indication he had a prior criminal record. He does have a young daughter, I think, that was born in 2014. So he's a young man. Had a high school degree, had some mental health issues, a tough childhood.
Thank you, Counsel.
Thank you.
May it please the court, John Sarando on behalf of the District Attorney's Office. I think before you consider whether or not his sentence is excessive, you have to consider what he did. And in June, he broke the child's leg by stomping on it. In July, around the 4th of July, he threw the child across the back seat of a vehicle, causing a subacute brain injury. And then on July 12th, he repeatedly struck the child, killing her. This was a 3-year-old child who the defendant indicated at the, I think the pre-sentence report, but indicated in court that he snapped because this 3-year-old child needed a lot of attention and nagged him constantly. So all of the
The point is that instead of him taking responsibility, he's blaming the child for this result.
And it's sort of an aggravating series of events that resulted in the crime. In addition, as to his claims of pressure during the plea bargaining process, the judge pointed out that he could get 57 years. He did not promise the max. Generally, a sentence is longer after trial, and he was not guaranteeing the max. And has Justice Centra, Justice Peridotto, and Justice DeJoseph found in the Ware case, it's hard to say you were threatened and coerced when you deny that you were threatened or threatened to plead guilty. And that is what should control. Insofar as the waiver of appeal, he orally waived his appeal. He executed the waiver of appeal form and the post-conviction form.
Well, we know this. The objection being made here really is to the severity, not the quality or the plea itself. It's really directed at the sentence, severity of it.
And right, and then in Rodriguez, which I think Justice Carney was sitting on, the court said that you waived the severity of your sentence even though it wasn't specifically mentioned in the waiver. So we submit that the judgment of conviction should be affirmed. Thank you.
Thank you, Mr. Sarando. I'd like to acknowledge that we have present in court today the Honorable Salvatore Martocci, who's a former member of our court and an esteemed member of our court who's joined us here. He's going to participate in the CLE, so I can encourage you all to attend after the session of court. Welcome, Judge Martocci and his wife. Welcome. Next case on for argument, 1135 Vaccaro versus Vaccaro. Proceed, counsel.
Bruce Intellisano, attorney for appellant Matthew Vaccaro. May it please the court. My apologies in advance. Don't let this gray hair fool you. This is my first case after being sworn in this department last year.
Oh, welcome.
Thank you. You might say this is a real life my Uncle Bruce instead of my cousin Vinny case. My first case is, as you know from the pleadings, representing my nephew. My client first came to the court below when the mother would not stop, even after proper written notice, pre-trial page 48, violating an original court order of custody and visitation in this matter. She withheld the agreed-upon first right of refusal, and after the trial below had ended, while the decision was pending, for nearly 6 months, she was further emboldened and simply stopped allowing additional visitation, more than two.
So let's get right to what the issue is before us.
Yeah.
The custody arrangement was modified by the trial court below to eliminate your client's morning visitations with the child. That's what happened.
And first right of refusal.
And first right of refusal, okay. And the court found that that there was this increasing animosity between the two parents. I don't think you dispute that that exists.
No, I think I do in my reply brief to Ms. O'Hanlon's very credible brief on behalf of the child. I think I point out some of the standards in your previous decisions that Ms. O'Hanlon...
I'm not talking about the standard yet. I'll get to that.
Okay.
But the question, or the point I was making is that the court found, based on what it heard, that there was increasing animosity between these two parents. And so, and that manifested itself during these morning visits and drop-offs. And so, in the court's view, it was in the child's in the court's view, that constituted a change of circumstances. You say that's not the proper standard. And the court found that it was in the best interest of the child to kind of eliminate this drama.
I understand, and I just don't believe there's enough in the record on appeal that supports that. In fact, you'll see, and I'm no judge, clearly, but I went through the exercise in my brief and opened the door wide open for opposing counsel and attorney for the child to come in. I do my own pseudo determination of, what are the kind of things that should be considered by the court before making that kind of a decision. And in support, or to support what I'm saying, Ms. O'Hanlon actually did say in her brief that a lot of those things are, well, what do you mean and how do you know? Well, that's my point, you don't. And none of them, neither party, said anything in those sections of the 4 different things this court has recognized should be considered. Neither of them provided any of those things in support of the decision of this judge.
What things are you talking about?
Well, so in my brief, I lay out the 4 different things that are generally considered to determine whether a change of circumstances is necessary.
Can we stop right here?
Yeah.
There's a petition and there's a cross petition.
Mm-hmm.
In both petitions, parties are arguing there's a change in circumstances. So it seems to me that everybody agrees that there's a change in circumstances here.
Well, I think that...
your client says it, opposing party says it.
Yeah, my client's change of
Does that satisfy that prong?
There is an argument, I agree. My client's argument is that Ms. Vaccaro is withholding first right of refusal, and can any of you not imagine that necessarily ending up in arguments?
Okay, so the point is that both parties, so the point is we get past change of circumstances. So really all we have to look at is whether the determination by the trial judge was in the best interest of the child, right?
Well, I think if you look at Friederwitzer, and again, I know that the attorney for the child doesn't like that, but I would say that in Friederwitzer, like the case before you today, the mother was violating a stipulated agreement. Here, like there, the trial court was asked to disturb that previous agreement. And the type of agreement that should absolutely, in my opinion, and I know it's been a little bit different here, be given the highest priority as it represents the best solution in any divorce, because an agreement between the parties, all right, each presumably knowing what's best for both. Not an agreement after trial where a judge, essentially a stranger to these personal circumstances, is forced to make a decision within the boundaries of the law.
Yeah, but the difference is when there's no agreement, when an agreement breaks down, then the court...
You have to look at...
Here's the proof.
Right.
And of course, if you don't ask if there's some type of informal or formal agreement between 2 parents, that's always the best situation if they're getting along and, the child is thriving or the children are. But when that agreement breaks down, then the court's cast with the duty to hear the witnesses and make a decision on what's in the best interest of the children. And that's what we have here. I'm interested in this, though. In other words, that I understand the proposition that, if both folks say, hey, I want a modification because it's not working, then really, for purposes of the lower court, all that's before the court is what is in the best interest of the child. But if I understand at least partially your point is that is critical to get over the hurdle of modification. In other words, what are the grounds, you know, who's believable? You know, okay, maybe they're both not getting along, but, you know, who's proven, you know, what party's proven their elements as to the modification may be critical when you cross over into the best interest.
And in Friedewitzer, I think they recognize the value of these agreements, and for the basic reason that you don't really want to disturb custody arrangement because that affects the best interest of the child necessarily, yanking her out of a normal routine and changing it all up. So
unless there's a good reason to do so. We get that.
Yes, and in my opinion, this court can and should synthesize the real need decisions that you've made by better defining what it is, a real need for change. I think you have an opportunity here to take these decisions, and Ms. O'Hanlon put 7 or 8 different ones in her brief. Many of those decisions, many of them, have determined the real need at the heart, I think 4 out of 7, or 3 out of 7, centered on the interference with non-custodial visitation as a major problem. It's per se evidence of an unfitness to be the custodial parent. That's a matter at the heart of this case here, okay? But it's a matter that wasn't even addressed by the court below.
Counsel, you should begin to wrap up.
Okay. Beyond the real need issue, we do have the simpler way out here, Your Honor, and that's the statutory issue, okay? And in the statutory issue, 205.14, in any matter to determine temporary or permanent custody or visitation once a hearing or trial is commenced, it shall proceed to conclusion within 90 days. This court's only had an opportunity to mention that once that I saw, and it was in matter of Jody and Lynn M., 43 AD 3D. The timeline in this case, almost a year and a half, is laid out in my brief.
Does the statute provide any sort of remedy or penalty for failing to comply with that requirement?
Well, it does provide the word shall, and shall is a word of ordinary import based on McKinney's section 232.
No, I know it shall, it says the court shall do this, but
Yeah. Well,
does it say what happens if the court doesn't?
And in that case I referred to, all you did is admonish because there was no opportunity for you to decide because the case was otherwise disposed of. So you did take the opportunity to admonish.
Counsel, I think we understand your argument, and,
Okay.
and we'll address it. Thank you.
Good morning, and may it please the court, Your Honors. My name is James Rizzo, attorney for the respondent, Vanessa Vaccaro, the mother in the case.
Can I ask you just a procedural question? It's, you know, I'm just
sure
to figure out, and I don't mean to put you on the spot, but there were 2 other orders that were, you know, I know that this was just this decision order was appealed from, but there were 2 prior orders.
Well, Your Honor,
we dismissed for failure to perfect.
Your Honor, there's been numerous orders, and I know Mr. Antelesano frankly admits that this is his first case.
Yeah, I don't want to get into all the numerous orders. I'm just more curiosity because it seemed like it came up, it would come up and be dismissed relatively quickly because I was having a hard time following
that is correct, Your Honor. This is the 4th attempt for a reconstruction hearing. In 24 years of practicing law, I've never seen such a frivolous, if not sanctionable situation. And I don't say that lightly because I know that's serious.
What effect does that have on what was appealed from today, I guess is my question.
Well, Your Honor, he brought a motion to the lower court for a reconstruction hearing. That was appealed to this court, which was unanimously denied. So that the exact same relief he's requesting. Then he went back to the lower court, made the exact same motion again. That was denied. Then the lower court tried to accommodate him to the best he can. He stormed out of the courtroom and said he was not going to partake in that.
And that second order you're talking about was dismissed by us for failure to perfect?
No, it was denied in all respects. The motion for a reconstruction hearing was denied in all respects by this court.
Okay.
And that's cited too in the record.
Yeah.
Both in my brief and in the attorney for the child's brief. And then he made 4 extensions to perfect the appeal, which it dragged out over 18 months. So when he talks about a delay of the lower court, that's approvable. It's in the record that he made 4 extensions that were granted by this court.
Yeah, but what appeal, you know, I don't want to get you off your game here. What appeal was, that was an appeal from the lower court that was not perfected and we dismissed.
Oh, correct. So I believe you're referring to.
I'm trying to figure out what issues,
yes,
were dismissed that perhaps are relevant to some requests that he's making here.
Yes, Your Honor. He did make a motion to actually disqualify myself as an attorney in the case.
Okay, so we don't need to be concerned about that.
Correct.
We're more concerned about the, the idea of this either reconstruction here, or the idea that the record was inadequate.
That's correct, Your Honor.
Is that the second order?
Yes, in your appellate clerk did send a letter stating that 2 appeals that were filed were in fact dismissed and not perfected. And yes, one of them was a motion to disqualify myself as the attorney in this case.
Okay, thank you.
You're welcome. So very briefly, because I certainly gather that Your Honors are familiar with the case, to address Justice DeJoseph's point, Appellate not only wants it both ways, they want it all ways. They did file a petition claiming change of circumstances, absolutely unequivocally. But now that they got a decision they don't like, they simply are saying, oh no, there's no change of circumstances because we got a couple modifications that were in favor of the mother, so now there's no change. So completely inconsistent. I mean, the record shows that. I don't believe I need to elaborate on that point, but that's absolutely why what even brought this whole situation was a petition by the father of change of circumstances. Then to claim that there's not animosity between the parties, 5 orders of protection, 5. And a finding in this decision that's being appealed before, Your Honors, that there was a violation of the order of protection. There's statements in the record, animosity from both sides, scolding by the judge of both parties, basically saying, cut it out. That's acknowledged, that's clear in the record. I won't repeat the exact words, but it's very clear in the record. One of the many abusive domestic violence type statements, your mother's a piece of blank, clearly on the record. These sound like parties that are getting along. So, it's very clearly stated, 11-page, single-spaced decision, findings of fact, character evaluations. If every case had to be overturned or retried because there's gaps in the record, I guess we'd have to hire probably 50 more judges to retry every single case because that's just a fact of life in court.
We can decide whether the record's adequate for our review.
Yes, thank you, Your Honor. Just one additional point, because he spends pages and pages on this and brought it up again today. And this is what I believe really is sanctionable conduct because it's absolutely material misleading to this court. He keeps saying that the mother lied under oath, that she was in flagrant violation of the order, and then attacks the lower court judge and makes a false statement about her, saying that she allowed it to go on without any hearing, violating his client's constitutional rights. It didn't happen in reality. It did not happen. There was a motion. It was heard. Both parties were there. Both parties had availability of counsel. There was a written decision. Yes, she made a bench decision, and I'm referring to the before the bus visitation time. And she made a written decision that based on the circumstances of the case, and she did say, yes, my full decision is pending, but because this is an issue now, I'm making a decision that, yes, the mother can do this. So that is a written decision on the record. He's misrepresented that. He spent pages and pages, not even a sentence about
Counsel, we have that argument with respect to sanctions. I would move on.
Thank you, Your Honor. And we do fully support the very objective and detailed brief of the attorney for the child. I believe she hits on all the points. And with that being said, I do believe that nothing but sanctions will stop him from filing a 5th motion before the court. And I don't say that lightly because this is hours and days and weeks have been spent over this issue. Thank you,
Counsel. Counsel?
Good morning. I'm Sharon O'Hanlon. I represent the child in this matter. What I would like to do is to update you as to how this modification has impacted my client.
Please do.
Thank you. So the modification has had actually a minimal impact on my client. The impact it has had has been positive. As predicted by the lower court, reducing the amount of contact between these parties has reduced the drama that occurs in front of my client, and that's been a positive result of the modification. In addition, with regard to the morning visitation, I need to make clear, and I'm sure you know from the record, we're talking about either 3 mornings a week or 4 mornings a week of the mother's parenting time. So instead of going in the car with dad for 10 or 15 minutes to drive to paternal grandparents to have breakfast, to get on the bus from there, my client now goes a minute down the road to the maternal grandparents. She has breakfast with her young cousin, and she gets on the bus there. I mean, it really, and the benefit is that she gets to sleep 10 or 15 minutes later in the morning. It really hasn't impacted my client, but it has reduced the amount of conflict and drama that she has witnessed between the parties. If there are questions, I'd be happy to answer them, but otherwise, I do believe that the lower court's decision should be affirmed, and I rely on my brief for those points.
Thank you, counsel.
Thank you.
Case 1137, Bodaroff versus Bodaroff.
Good morning, Your Honors. Susan Maris, attorney for the children, Catherine and Christopher. May it please the court, as appellant is on submission.
I'm sorry, can you hold up 1 second, counsel? Thank you. Please proceed. I was having a tough time hearing you.
As the appellant is on submission, unless there are any questions, I'll rest on my brief.
Very good. Thank you, counsel.
Thank you.
Case 1138, Upstate Forestry and Development versus McDonough Hardwoods Limited.
Good morning. Thank you for coming to Syracuse.
Thank you. Glad to be here. Please proceed.
This is a case between a forester and a sawmill. Forester is the plaintiff, sawmill is the defendant, my client. There were several contracts between the parties where the forester bought woodlots from owners and then reassigned those contracts to the sawmill. The sawmill would then saw up the lumber and saw up the timber and make it into lumber and sell it to their customers. There was an agreement between the parties that if the amount of timber did not come up to what was represented at the beginning, that there would be a makeup of other jobs that would be given to the sawmill to make up for the shortages.
Is that an oral agreement?
It was. So when the case came to the Oswego court, there had been a discussion between the parties at McDonough's office where it was acknowledged that the forester was going to owe a lot of money to the sawmill for the shortages. The next day or the day after, the sawmill was served with summons a complaint based on 4 contracts out of several contracts. That was a legal tactic that was the way the case was started. The sawmill counterclaimed for the rest of the contracts and for all of the shortages.
Counsel, let me ask you this, if I can kind of cut to part of this at least. The counterclaim involved, I think, contracting regarding the Rusin, right? Rusin, thank you, the Rusin contract. And plaintiff didn't sue on that contract, is that right? That only came into the litigation as a counterclaim by your party, is that right? Or your client?
It did, yes.
Yeah, yeah. And yet the court awarded, as part of this litigation, an award on that contract to the plaintiff, although it wasn't part of his claim. Is that fair? Do I understand that correctly?
Well, the Russian contract was one where the forester paid Russian for about $40,000. Then the forester reassigned the contract to the sawmill for $230,000. which represented a huge profit to the forester. The usual commission, according to one of the other witnesses, is about 15%. So the forester diluted Russin when he paid him only $40,000 on a very large contract. When the court made its decision, in this case, the final decision, at first the court dismissed all the counterclaims based on the UCC, strict interpretation of UCC. So we made a motion to re-argue, which was granted, and then the court allowed trial on all of the issues. Defendants' proof went in completely and included some of the court's own allowing of the loggers to be shown as experts, even without a motion. So the defendant had an opportunity to put in everything, which means, in my experience, there's nothing to appeal when the defendant's case is then dismissed, as it was in this case. So we have to look in the record for basis for appeal. Russian case is part of that record, and the argument is that if the court relies on the credibility of the parties, that in the Russian case, the forester who had deluded and defrauded Russian testified in this case and was shown to be somebody who probably did not tell the truth to Russian and could be found not to tell the truth to the court in this case. All of the...
So are you saying the court was making credibility determinations below and then making them inaccurately?
Say again, sir?
Are you saying that the court made bad credibility determinations below relative to the witness's testimony?
Oh, yes, sir.
Yeah. Now, isn't the court in a better position below to assess credibility than we are here?
Except for well, I'll just explain very quickly. We're using Russian as one of the reasons why the court should have found that the credibility of NYAppDiv4 or the forester was incredible. The other one is by submitting this witness who was Kellen Murphy, who determined that on another contract that the amount of timber and the pricing under the DEC region printouts reports that they have about pricing.
They were using the wrong pricing mechanism?
Used the wrong pricing and the wrong amount of timber. So there were two people in this case who were not credible, and substantially not credible. Russian was one of them, and Colin Murphy was the other one. The court then dismissed
So you're asking us to take a look at the record and assess credibility and find that the court below improperly assessed credibility. Is that what you're asking us to do? In other words, you're asking us to take a fresh look at the witnesses, and if we find them to be incredible, then that's what you'd hope we do. Is that right?
It is.
Okay.
And but the court dismissed all of the counterclaims twice. The first one was based on the UCC, and the second one was at the end of the case. The court said that there would be a determination at the end of the case because he did not vacate the dismissal based on the UCC. But he never made it it's not in the record that there was a determination made like that, but it seems that he allowed it to go forward as a trial and still dismissed it. So we think that our witnesses should be looked at as credible witnesses.
You should begin to wrap up, counsel.
That's the answer, Your Honor.
Thank you.
Thank you.
Good morning, if it pleases the court. Ryan Susser with Bousquet Holstein for the respondent, Upstate Forestry and Development. Your Honors, this is a complicated case that was tried over the course of 4 days before Judge McCarthy in Oswego. So Mr. Pratt did a good job of explaining generally the contracts that were at issue, but if you'd indulge me, I just go back for one moment. There were 4 timber reassignment contracts at issue in plaintiff's complaint. And a timber reassignment contract is essentially that my client is acting as a middleman. His company is going to buy the right to cut timber.
We understand that.
Okay, all right,
In other words,
great.
he goes out, finds a landowner that, has a number of trees. He's been doing this a while. He sizes it up, figures out what the value is according to what it could be sold to the mill.
Yep.
And in essence, assigns the contract to the mill. And sometimes they're right in the ballpark, sometimes they're outside. And I guess the first question we were asking, I think Justice Perodato, was, were these sort of implicit agreements relative to whether it wasn't, if he didn't estimate it right? Is that in writing? And I assume the question was, because we're dealing with the parole evidence rule.
Yep.
And so what do you have to say about that?
You're absolutely right, Judge, and so thank you. Yes, the answer to that question is no, and I call it in my brief the 10% agreement. Essentially what defendants advanced at trial was that they were told orally that for the price they were paying, there would be a particular yield. If there wasn't that yield within 10% of the yield that my client told them, they would be paid back in either cash or an assignment of another contract. During trial, when that very same witness who was testifying to that 10% agreement was asked, well, what happens if you received more than 10% of the yield? What would happen then? And he said, well, I don't know, that wasn't a part of it. And so it really, when you talk about credibility, everything was pointing to this party wanting it both ways. If it was a good deal and he made more money than he thought he would, then he would retain that profit. If he didn't, then he would attempt to put that back on my client. The thing is, not only is this a parole evidence rule, this is a statute of frauds because this is a UCC case. So the contract must be in writing. This 10% oral agreement may not be oral and may not be enforced as such. There was some course of dealing and course of performance argument introduced in a trial, but the court rightly found that there actually wasn't proof of that. There was only one other contract where they alleged this had happened. That hadn't actually happened the way they said it.
So they didn't do it enough to meet out the UCC?
They had only ever done it once, according to the defendant, to McDonough. So that's not a course of dealing. It's a course of performance with respect to a contract that wasn't an issue here. The other thing that I would point out, Your Honor, is that the question was asked, were the damages actually awarded on the counterclaim? And so just to sort of, the way that Judge McCarthy handled this was that we had a total of 7 contracts at issue.
Yeah, but not,
go ahead, Judge. Oh, yeah, sorry, Judge.
But only 4 contracts were part of your claim,
That
your
is true.
affirmative claim. The
Yes.
other 3 were part of the defendant's counterclaim.
That is absolutely correct, Your Honor. And what the position we took at trial was, okay, the elements of a breach of contract claim are going to be that there's a contract, performance, breach, and damages. In our 4 contracts, we alleged breach for non-payment. In their contracts, they alleged breach for something else. But in order for them to prove their claims, they needed to also allege performance by them. And so the judge's position was, Ryan needs to show non-payment on his clients, on his contracts. Willard needs to show payment on his contracts. And the way that he did it was he looked at it as a universe of 7 total contracts. Let's determine what's owed on all 7 in total, and then whatever's left over is one of the
but can he do that when the claims are separated by the complaint and by the counterclaim, and it doesn't quite match, so to speak?
I believe that you can, Your Honor, because I believe that it was appropriate to do that in this case because we had...
It may have been appropriate, but was there something, I didn't see anything in the record where the court conformed the pleadings to the proof. And isn't that really something that needed to take place so that the parties were on notice that that was happening?
The judge during the trial, from my recollection, was pretty clear that he was going to take the position that each party needed to prove payment on each contract. That because these parties had dozens of contracts with one another over the course of their time dealing with one another, that just showing an amount of payment wasn't enough. You had to assign it to a particular agreement, and that's ultimately what the judge found was deficient. It was fortunate that the judge could, for the contracts for the complaint, because those 4 contracts took place after 2015 and the parties had no other dealings with one another after 2015, you could just say any check dated after 2015 goes to those 4 contracts. But the other checks, you had to show somehow that they were associated with some particular contract.
There is one check I have a question about, and I'm glad you brought this up.
Yeah, sure.
It's check number 15471.
Yep, that's the one.
$30,000. Isn't that really what we're talking about here?
Yes.
You were awarded $30,000.
That's correct. And when you look at Judge McCarthy's decision, it is consistent with the position that he'd taken throughout the trial, which is, again, when there's checks dated after 2015, they can only apply to the 4 contracts in the complaint because there were no other contracts after 2015. But there was a lot of testimony that there were many other contracts not at issue here before 2015. So the judge said, and I think this is well within his right to assess credibility, McDonough had check stubs with each check that would identify, according to their own records, which contract they believe those checks applied to. With respect to this check, they didn't. And the judge determined, as a matter of credibility, well, if you can generate stubs for the other ones, that means that you meant to pay them for these contracts.
Yeah, I don't want to break your stride, but
no.
Is that award or credit, is that part of the 4 timber reassignment contracts that you sued on?
In my opinion,
let's forget about what the court did.
Yes, Judge.
If I had your pleadings right in front of me,
yes.
Is that one of the 4
yes,
contracts
Judge.
that you sued on?
Yeah, well, because if the other contracts were not at issue at trial, the other 3, then it would have been a different set of proof. We would have not just acknowledged those other checks from 2015. We probably would have taken the position that some of those, like the same that we did with the pre-2015 checks. Well, you have to assign them to those contracts. My client's position was he wasn't paid at all. And so all the proof came in as one big payment.
Are you suggesting when the payments came in, your client was applying those to, maybe the right or wrong contract?
My client wasn't applying them at all. He was just getting paid over the course of time, and
he treated it as a bulk.
Just treated it as a bulk.
I'm owed X, and
that's right, Judge, and that's what the trial judge did. Is he just said, okay, we need to look at it globally because I'm dealing with all these contracts. Yeah. If he hadn't, or if these contracts weren't an issue, these other 3, then the trial would have been different.
Counsel, you should begin to wrap up.
Okay, sure, certainly. If you don't have any other questions, thank you, Judge.
Thank you, Counsel. Case 1139, John Mezzalingua Associates LLC versus the Travelers Indemnity Company. Thank you. Thank you.
Good morning, Your Honors. May it please the Court. Gregory Varga from Ferb Robinson & Cole for the appellants, Travelers and Phoenix Insurance Company. Your Honor, I want to point out that this is not a garden variety disclosure dispute. This is a disclosure dispute in a $50 million commercial case, as claimed by the plaintiffs, that involves the withholding of not a handful, but more than 550 email threads and other documents that were protected by them and withheld by them on the basis of several claims of privilege.
Yeah, so we're not dealing whether or not they're material and necessary. Are we really dealing with the 3 privileges?
That's correct, Your Honor.
And
material and necessary really isn't much of a question at all. Isn't a question at all in this case, and the trial court didn't really address that.
Yeah, and as I understand your arguments, at least relative to the anticipation of litigation, that your argument is that the court improperly accepted the plaintiff's subjective claim, and that was in error.
That's correct, Your Honor. The court did accept the representation that counsel anticipated litigation when a reservation of rights letter was issued 4 days after the loss occurred.
The wrong date.
No, well, our position is that the court applied an event cutoff and then said every document that was involving these parties, or these third parties, after the date of the reservation of rights
No, I understand
is protected.
That, right. Yeah, in other words, there's a difference between a reservation of rights and an outright disclaimer or
Absolutely,
denial.
it's an extraordinary concept and rule that the court created here, because in essence it's saying whenever an insurance company issues a reservation of rights letter in which it says, understand, claimant, we are investigating this loss subject to, and your rights are reserved and our rights are reserved. What the court's saying is immediately, automatically, litigation is on the horizon.
Well,
and there isn't precedent for that
in essence, Justice Carney pointed out, we're dealing with the court's view of the subjective aspect of it. But going back into the privilege, when I went through the privilege logs, very few were listed, as you mentioned earlier, regarding material, material prepared, material prepared in anticipation of litigation, material aspect of it. But it appears that there was redaction, heavy redaction, using your words from your brief, and the fact that and the court never saw any of these documents.
The court did not conduct an in-camera inspection despite our requests. The court had before it the arguments of counsel in briefs and privilege logs, but did not conduct an in-camera.
It seems that the court didn't think that it needed to, because it presumed that anything after the cutoff date was prepared solely in anticipation of litigation. That seems to be its conclusion, right?
Which is the significant error.
Which is the problem.
Which is a problem because a party withholding material in discovery is not entitled to a presumption. What the court must do is ask them, make them prove the elements of each privilege that is claimed.
The burden's on the party. The burden's on them.
I'm sorry, Your Honor.
The burden is on them.
The burden is on the party withholding the discovery.
So let me ask you this, relative to the anticipation of litigation, assuming we buy into your arguments, what would you ask us to do? Would you ask us to set a date? Would you ask us to review those documents, or would you ask us to send it back?
I would ask the court to reverse and remand with instructions for an in-camera review, and we had proposed that to the trial court, and in fact, to save the trial court a burden, we had proposed to have a third party designated by the court at the defendant's sole expense.
Yeah, but I understand that you've got two arguments here. At least let's deal with the anticipation of litigation. You've got wrong date, and you got to look at them, right? So are you asking us to pick a date? Are you asking, and then the court is to, in other words, would you say that, that we should be saying that the date, the critical date, is the date of a disclaimer?
That is certainly, I would say, the earliest date that one could say litigation is reasonably anticipated. Yeah, okay. It's not a question of when do they say they actually subjectively anticipated it. When do objective facts exist to create an imminent threat of litigation or a clear resolve to litigate? That's the test. And the trial court did not apply that test here. It focused on the subjective. And it's our view, Your Honor, that the concern here is that if the court were to have the luxury of reviewing the privilege log, you would see that the documents that were withheld on the basis of privilege include, and I just want to list these, collections of documents as to which they claimed attorney-client privilege that were not authored by or sent to a lawyer. And there are more than 100 of those. Documents as to which they claimed attorney-client privilege that were sent to third parties, including one of the defendants in this case, Marsh.
Yeah, now you've jumped into the attorney-client privilege, and your argument there is that they shared them with third parties, as I understand it, and that you're saying that the plaintiff has the burden to establish that there's an agency exception.
They have to prove the Koval exception, the U.S. v. Koval, clearly. But all I'm pointing out is that we really, respectfully, we were entitled to a greater level of scrutiny for the materials that were withheld, and we understand that an in-camera review is burdensome and that the court's time is precious. We appreciate that, but it doesn't mean that the plaintiffs then are entitled to a presumption that everything after a date certain.
I think we understand that argument, counsel.
Thank you. Unless there are other questions, Your Honor, I will.
Thank you.
Thank you for your time.
Good afternoon. Brady O'Malley, I represent Campany Roofing. Unless the court has any questions, our arguments echo Mr. Vargas. I believe he did a good job covering them, and the court seems to understand the issues. Thank you.
Thank you, Counsel.
May it please the court. Patricia Lynn Ford on behalf of Respondent John Mezzalingua Associates. I'd like to respond to the appellant's arguments by shaping it a little bit differently, and that is by asking the court to direct its attention to the scope and purpose of the commercial rules, because this case is governed by the rules of the Commercial Division of the Supreme Court, and it also pertains to the trial court's inherent discretion to supervise and direct parameters for discovery, to decide discovery issues, and in particular, the discretion afforded the court under the rules of the Commercial Division, the Rule 11 authority. Now, this case is a water damage claim. What makes it expansive is the damages that pertain not to the physical damage to the building, its facilities, and its equipment, but rather the damage caused by the water intrusion that the plaintiff, John Mezzalingua, contends caused business interruption. So exercising its discretion, the court bifurcated discovery consistent with the purpose of the commercial rules, which is to, quote, encourage proportionality in discovery, conserve client resources, promote efficient resolution of matters, and increase respect for the integrity of the judicial process. Also in the commercial rules, the court is afforded the opportunity to decide discovery issues that limit discovery. It's expressly provided with that authority by the rules of the Commercial Division, and in fact, it's encouraged to do so. Now, the court below did this through phasing discovery. Phase 1, liability. Was there a breach of the insurance contract? If so, what was the physical damage in the immediate aftermath? Now, that's a defined period in time and a defined scope of inquiry. Water damage, what caused it, who saw it, what did it damage, who cleaned it up, and how much did that cost? Phase 2, which is more expansive and more expensive for all the parties, the discovery phase, was held in abeyance after motions would be had on Phase 1, with the objective that maybe we can resolve this lawsuit. So fast forward to the year of back and forth on all of the discovery issues. The court also exercised its discretion to do date-based discovery parameters. And it did so recognizing not just on the basis of a reservation of rights letter, because that would not necessarily be the case in every insurance claim. But in this case, John Mezzalingua Associates retained counsel virtually that day, litigation counsel, not in-house counsel. In-house counsel was involved, and that counsel's name is on many of the emails. But they retained litigation counsel. The day, virtually the day, within a day or two, counsel was...
Why does... Oh, excuse me, Judge.
Yes, Your Honor.
Why does that change the equation?
Well, because litigation, then everything that happens with the involvement and under the direction of litigation counsel is arguably material prepared for litigation.
Material solely prepared for litigation? Because that's really the test.
Well, the test for solely prepared for litigation applies to the material withheld. What wasn't made clear in appellant's arguments is that many, many documents were produced for that time period following the reservations of rights letter. And the court below acknowledged that in its written decision, that all documents not already produced, or the privileges afforded to documents that haven't been produced, but which have been identified in the privilege log. And this privilege log isn't completely subjective, because it contains objective identifiers as required by the Commercial Division rules, dates of the emails, to whom it was sent, and subject. I'm not asking the court to review these hundreds, if not thousands of entries, but they say things like, how did the traveler's call go? Strategy meeting, status of claim. I mean, that's the ray line.
Yeah, let me have you take one step back. So if I understand your arguments, your argument is that you appreciate the fact that a date of a reservation of rights letter is not necessarily the gatekeeper for whether you anticipate litigation. But in this particular situation, because not only were the lawyers involved or hired, but they were litigation lawyers. And so perhaps the subjective view of what was going on is important because your folks, based upon their conduct, anticipated litigation?
I think that is a distinction. I agree, Your Honor, that this particular client anticipated litigation based upon their reservations of rights letter, perhaps, who knows why, but they retained counsel. And at that moment, a trial attorney is ethically bound to protect information they gather in the course of preparing a case for litigation. And virtually all of these communications have the name of a lawyer on it from the litigation firm. The few that don't contain the privilege, the 3101D privilege, and that's the basis for the court's decision below. The court put it under that umbrella.
Counsel, what's the harm of their suggesting an in-camera by the court? Because I did look at some of the privilege logs, and it just seemed to me that when there are communications to third parties, which you're saying that they fall under the privilege, what's the harm of a review?
I wouldn't say there is, well, that's, I guess, the question for the court administrators in the court, because the whole purpose of these commercial division rules, there's a whole section on privilege logs that prefers categorical. But in this case, the defendant's attorney requested document by document. And the purpose of these logs will be completely, what's the point of it? If it's not, there is not one item that the defendant has withdrawn or retracted during the entirety of this discovery dispute. Not one. You know, I mean, that's kind of a shocking thing.
I recognize. What gives me pause, though, is that the court, as you mentioned earlier, doesn't really addresses the attorney-client, denies it based upon privilege, which the court did. That's what the court's decision was. But it doesn't seem to have looked at the documents or looked at anything whatsoever to come to the conclusion. It seems that the decision it made was strictly on the date of engagement and nothing more, nothing less. And you seem to be arguing, at least my understanding, the substance of it. When you look at the privileged logs, there's nothing really there and they are privileged. But it doesn't seem that the court based its decision on that.
Well, the court based its decision, Your Honor, on the privilege 3101D2, material prepared for litigation, which is a broad privilege. It's a conditional privilege. Any writing or anything created by or for a party or his agent in preparation for litigation, it's conditional to the extent that a defendant or an opposing party can argue entitlement to it if they can prove that it affects a substantial right and they cannot otherwise obtain that information without undue prejudice. So the parties have gone through this exercise of producing discovery. The trial court has reviewed it. And I think the trial court did more than just look at a date and say, you were hired as counsel, everything after that is protected, because the record is expansive. It's a 2-volume record of information that court considered. And now we're saying to the court, who has been afforded all this discretion by the commercial rules to streamline discovery, to make discovery issues, and say, you know what, you need to go back and review thousands of documents for which the party has claimed privilege.
You know, you've referenced, and I understand why, the commercial rules and the reason for the commercial rules, and to expedite, you know, discovery, to get the litigation done so that the parties can get their matters resolved promptly, and that's been an overreaching goal, I think, of the commercial parts in our state. And part of that is to assign a judge with particular skill set that has an ability to handle these commercial cases. And so what I kind of join in the same question that Judge Gentry has. I mean, here we are on appeal. That certainly isn't streamlining anything. And a look at these documents, an in-camera look at these documents by the judge below might have been the best and most expeditious way to handle this matter. But we have your argument, counsel. Do you want to wrap up?
I do, but on that point, I'd like to say one thing. The commercial rules, if that's the case, then the commercial rules should provide that in any case where there's a dispute over a withheld document identified in the privilege log, in-camera review must be required. I think the commercial rules did not so provide, And in such a case, the discretion of the lower court, who's most familiar with the facts and issues, should be afforded due discretion. Thank you.
Thank you, Counsel. We're going to take the next case out of order, calling case 1141, 1142, and 1143 in the matter of John Z. versus Teresa M. Girard. And yes, please proceed, and please approach.
I am appellant John Zavala-Droga. Guardianship frauds that are committed by
Hold, if you hold on a second, I just want to make sure there's not somebody else appearing on this case.
The court clerk told me that the other party would not be appearing.
Would be submitting. Okay, well, please proceed, sir.
Okay.
Sir, let me do this for you. Let me see if in reading your papers, let me see if I can formulate the issues that I think you're trying to present to the court.
Okay.
And then you tell me whether I'm on the right page or the wrong page. How's that?
Okay.
So my understanding is that you've got two claims where the lower court ignored or erred. You know, the first one has to do with when the guardian argued this res judicata to defeat your motion to vacate for fraud, that she made an improper argument because she knew that it was not res judicata, and therefore, you know, we should consider it.
Yes, that's correct. In fact, the lower court judge, when he did rule on the motions that are being appealed today, he did correctly realize that res judicata didn't exist.
And you want us ultimately to get to the meat or the substance of your other fraud argument on these payments for attorney's fees and the payments to the Heritage Home.
And also the guardian sale of my mother's home. It was not until after the appellate briefs had been filed that I realized that the guardian had sold my mother's family farmstead to two of the guardian's friends and to the guardian's real estate business partner.
Yeah. So is your argument that just including but not limited to that the premises shouldn't have been sold, or that these bills should not have been paid also?
It is all of those things. The fraud encompassed all of these things.
Tell me why you think that your position as to why at least the Heritage Home bills it was improper for the guardian.
The way that the guardian obtained the money to pay those bills was by selling my mother's home. And the way that the guardian was able to sell my mother's home was by evicting the children, myself, who have lived there for more than 30 years while we maintained the farm for my mother and took care of my mother. And it would have costed just a few $100s to have fixed up when I asked to have the home repaired after some years. And the guardian denied the request, saying it was too expensive, and it was a deliberate attempt to create a sham eviction instead of fixing the home.
Are you saying to fix the home so that it would have reaped a higher sale
No,
price?
so that we could continue living there. I asked for money to fix some of the plumbing and the furnace, and the guardian denied that. Instead, she contacted a political crony in the codes department and asked to have the house condemned and have the family evicted immediately. And of course, the fact that the Ward's family was no longer living in the home made the home eligible for Medicaid reimbursement, and the guardian was thereafter able to sell the home under the pretext that no one was living there and it was necessary to pay nursing home bills, and that's what the guardian did. And of course, I did want to mention today that there's been a recent development just yesterday. It was after the appellate briefs had been submitted when I found out that the guardian had sold the house to two of her friends and to her real estate business partner, with the sale being for only a minor fraction of what that business partner had previously estimated the house's value. And thereafter, I requested a resettlement of the record in the lower court so that I could include property deeds of that sale. I appended the property deeds, perhaps improperly, to my reply brief. Anyway, it was just yesterday when we had a lower court hearing to resettle the record. And the lower court judge granted my request to include property deeds and business letters from the guardian's real estate partner in the record on appeal. Therefore, I want to request if I could have 5 days to file a post-submission motion so that I could send you the lower court's signed order with the property deeds. And I would prepare that today and have it to you, within 5 days.
You can, I'll give you permission to post-submit those documents on notice to the other side.
Okay, certainly. Yes, I also realize that pursuant to Rule 22 NYCRR 1000.15E that I have to make that request in writing, so you couldn't grant it. But in my closing moment, I just want to emphasize that the court proceedings brought by myself are the absolutely only reason in the world that the guardian's financial exploitation of our mother has ever come to light. Her intention was just to have sold the Ward's homestead to her business partner and reaped a tremendous financial profit in guardianship fees for herself. The fees that were mentioned in the orders being appealed were just for a few $1,000s. However, by now, I estimate it's over $100,000 in fees that the guardian has charged to my mother. And that's totally ridiculous. All she accomplished was to squander my mother's estate, which was worth an amount approaching $1 million. And now her business partner owns it. And actually, the business partner and the neighbors who bought it for some years, they had, prior to now, they had been planning to develop some sort of it's a farm on a beautiful lake. And they had been planning to sell like 1 or 2 acre plots where people could build vacation homes.
Sir, you should wrap up your argument.
Okay, but anyway, I just wanted to emphasize that the guardian's exploitation of my mother never would have come to light if it was not for the pro se proceedings.
Thank you, sir.
Okay.
Case 1140, Montefiore versus DiMatteo. Judge Carney is recused.
Your Honors, may it please the court. This case is essentially one of what does it take in order to establish vicious propensity of a domestic animal, a dog.
Let me ask this question, counsel. If in fact the facts demonstrate that neighbors witness the dog charging the fence, making loud growling noises as people pass by with or without dogs, isn't the standard what the owner knew or should have known? And wouldn't that be a jury question to determine whether or not a dog that's acting in that fashion throughout time, that a jury could be allowed to infer that the owner did know of those propensities?
I would say that that's true, and also I also have to deal with the fact that twice the owner admitted to knowledge that her dogs, 2 American bulldogs, would attack small dogs, didn't like them. She denies that specifically.
Well, it appears that the deposition testimony of your client says her dog, the defendant told her apologized, her dog didn't like little dogs.
Correct.
And then on further, you submitted an affidavit on page 130 that she said she went further and said not only did she say little dogs, but she said that her dog would attack small dogs.
Correct.
So we're on a motion for summary judgment. We have deposition testimony. We have an affidavit.
And I believe there was enough conflicting there to create a jury question.
Question of fact.
Thank you.
Thank you, counsel.
Good afternoon. Kevin Matheson from the Law Office of John Trott for the respondent. The court knows what the standard is in this case. It's whether or not the defendant knew or should have known of vicious propensities. And in this case, there is no evidence of that.
What about
Go ahead, Judge, please.
What about the statement of the plaintiff here, what the defendant told her?
Well, Your Honor, my client denies that.
Well, I mean,
From what I see, that as is a self-serving conclusory statement that has no other evidence in the record to even show that. This dog had no prior bites to a person or a dog. There was no evidence that the
But
defendant
counsel,
had.
that's the issue. You have the burden on this motion. I was not concerned what your client did say. It's what she didn't say. She didn't say those very statements that you just made.
That she didn't have any complaints. I believe she said that
My dog never bit anybody before. Did she say that?
I don't know if she said that specifically, but there is no evidence in this case that these dogs had ever bitten anybody else or another dog. I know that my client did state in the deposition that she had no complaints of her dog. The only evidence that has come forward of anything is this affidavit of my client's neighbor, who basically says that while she is walking by the house or jogging by the house, the dogs bark and approach the fence, or I think she said lunge at the fence. But as this court knows and as it's recognized, that normal canine behavior, like barking, it does not create a question of fact to whether or not this dog had vicious
Is it a jury
propensities.
question to determine whether lunging at a fence is normal canine behavior or a vicious propensity?
I don't think so, Your Honor. From what this court has already stated, that things like that, the barking and greeting people is normal canine behavior. If you look at the other cases, and certainly the cases that were submitted by the plaintiff in the brief, what makes the difference here is whether or not there is viciousness there. In all of those cases...
So this neighbor, part of the neighbor's affidavit, she said that she observed the dogs lunging at those who were walking past the defendant's property. I don't recall that kind of activity ever being described in any case as normal canine behavior.
Judge, what I would argue is that lunging and barking like that neighbor stated in that affidavit doesn't come to aggressiveness. It does not come to viciousness. And if we look at the other cases...
So that's where I think that maybe that becomes a jury question as to whether or not the description is different. You know, if you lump in lunging, baring teeth, tail wagging, and barking as normal canine behavior, some people might disagree with you on that. Some reasonable people on a jury may disagree, and they may say, no, I don't think that is normal canine behavior, and isn't that why we have juries?
Your Honor, that is why we have juries, but if we look at the case law, it looks, there is something else there to show the viciousness, like the growling, like someone confining the animal by leash or some other manner like that. Here, that's just not here. These dogs were in their backyard, fenced-in backyard, so obviously they don't run away so they can go to the bathroom. All those other indications of viciousness or aggressiveness are not in this case.
I think we have your argument, counsel. Thank you.
Thank you, Your Honors.
11-4-4, Coughlin versus Laxon, DVM.
Your Honor, counsel. May it please the court, I wish to call the court's attention to the nature of the statements that were made in reference to my client, Ms. Conklin. Ms. Conklin, you have to keep in mind that her profession was that of protecting animals.
And Mr. Cote, let me, in the interest of time here, you've got a tortious interference with employment and a defamation claim. As I read the complaint and I read the record here, your tortious interference cause of action hinges certainly in part on the defamation, and then you've got defamation. So maybe let's focus in on the defamation cause of action and the defenses that they've asserted. Let's talk about those.
Well, first question is...
Counsel, I'm going to interrupt you just for a second. I apologize, Justice Joseph. I should have announced at the beginning of calling of this case that Judge Carney is recused from this case also. So please proceed.
With regard to this matter, it's interesting that this woman who's dedicated her career to protecting animals was accused of, among other things, forcing others to kill cats which could have been treated and should have been treated. When the defendant made that statement, she must have known it was false because she herself had ordered the cat to be euthanized.
So that's
for
the actual malice component here?
I believe so. And that she also not only knew that that was false, she further went on to say that this woman had caused another cat to remain suffering throughout a night before it died. Again, the facts speak otherwise. And the question is, why did she say it? to show the malice. And the only reason was that, from the record, is that she herself was covering up her own errors. And the case has been very much trimmed down, because I do recognize that much of what the lower court judge said was absolutely right, on point. And that indeed the board members certainly had a right to rely upon what Laxon said to them, because they had no personal knowledge of them, and say, we believe that, and therefore you're discharged. I get that.
Is
But
that
in this
common
case,
interest, qualified privilege you're talking about here?
I don't believe it's right, and I understand that the board members themselves, one, are acting with qualified privilege, but more than that, to show malice, I think I would fail, because in that case, though each of them had a reason to believe what Laxon was saying to them, because Laxon being a professional person with personal knowledge. But Laxon herself had personal knowledge that those statements were false, and made them anyways. That's the distinction between the two. Also keep in mind that Laxon is not a co-employee or another board member. She was actually acting here as an independent contractor working only a few hours a week. She would come in, decide which of the cats or dogs might need referral to her private business, and otherwise played no role day to day.
If we assume for a moment that she is an agent or an employee of the SPCA, were the remarks and the statements she's making, is that in the furtherance of her position? Is that in the scope of her authority?
That becomes so far outside of her role.
And that's your argument, that she was protecting herself from a malpractice act?
Correct. And even if you put that aside for a second, let's say that for some reason you saw her agent for purposes of defamation, which is where it applies, it wouldn't apply to the other causes of action. So even if you said, well, she was acting in an agent position, that has nothing to do with these other type of matters, because you don't have a right, let's say somebody who contracts at my business, they do something for me, they write appellate briefs or something, and they came in and decided to spread things that they knew to be false about one of my associates, and that caused me to discharge my associate because I believed them. It turned out that it was entirely false. Did they have a privilege to do that? Particularly when it's stuff that cuts to the very heart of what it means to be a lawyer. Here, they cut to the very heart of what it means to be a person who protects animals.
That's your defamation per se, is what you're arguing.
Correct, Your Honor. Thank you.
Thank you, Counsel.
Good afternoon, may it please the court. Rob Thorpe on behalf of respondent Dr. Laxon. Just to address a couple of Mr. Cote's points, the issue of whether these statements are entirely false is rebutted by the very complaint that the plaintiff filed in this case. There are numerous text messages. Granted, some of them can be viewed as she's repeating what the board said during executive session.
I think when you look at the context, that argument makes sense to me. That she was communicating with someone else about, this is what they're saying about me right now. I mean, for the purposes of a 3211 motion, is that appropriate?
Well, I agree, and some of them in the context of she's reporting to another employee saying,
Correct.
This is what the board just told me. But then she says, record 266, can't argue with the board's points. I mean, she's summarizing exactly what was said in executive session. Now she's claiming these are false statements. She's saying, can't argue with the board's points. It's true, I made an irrational decision based on staff input and did not consult veterinary professionals. How can you base a defamation claim on something she's admitting is true?
Are you cherry picking that in the context of all what was said in those text messages?
I most certainly am. And it's,
Is that fair?
Yeah, that's fair.
Yeah.
And because the other statements, it's clear, at least on the record, that she is reporting to CJ Kelsey that this is what the board is saying. But I don't know how she gets around, there's 3 or 4 that I've cited in the brief that are clearly her own statements about her own conduct. And that's further buttressed by the fact that this animal advocacy group had come forward and said she did make a mistake. It was unfortunate, it's sad, but it was a mistake that she made. So to now say that these statements are false, it really is rebutted by her own admissions. The only other issue I want to address, the rest I think is addressed in the brief, is whether Mr. Cote has highlighted the fact that she was an independent contractor. And this is not a worker misclassification case. It's not a 1099 versus a W-2 scenario. Dr. Laxon was a volunteer for the SPCA, and she was an employee. And then she was a board member, and then during the time that he highlights here, she was an independent contractor.
I'll ask you the same question I asked Mr. Cote. Let's assume for the sake of our discussion here that she is, in fact, a representative of the SPCA. She's an agent or an employee. Were those remarks made within the scope of her authority?
Yes, Your Honor, I believe they were. I mean, if she's an agent of...
But they allege in the complaint that they were made to insulate herself from a malpractice action. Must we accept that allegation as true for the purposes of a 3211 motion?
And must accept all of them, it's true.
Okay.
And I do get that, but whether she was an agent or an independent contractor, and assuming for your hypothetical she's an agent, she had to act outside the scope of her authority. Here, it's clear she's an agent invited to a board meeting to give her professional opinion on the performance and the job duties of Karen Conklin. I don't know how giving her opinion at that meeting can fall outside the scope of her authority. As a former volunteer, as a former employee, as a former board member, she's invited into executive session to counsel and advise the board on that very fact. So I think that destroys not only her tortious interference claim, but also the defamation claim, because it falls within the qualified privilege.
Thank you, counsel.
Thank you for your time.